live, okay?
You're live, Judge.
All right, let's go on the record on cause number DC 209893, Moss versus Princip. Counsel, make your appearances.
Gene
Good afternoon.
DeBose for defendant Bone.
Good afternoon, Your Honor. This is Craig Capua. I'm here representing the plaintiffs, David Tyler Moss and Fidelissimus.
Good afternoon, Your Honor. This is Michael Hurst here on behalf of non-party Google and YouTube.
Anyone else want to make an announcement?
Yes, I do.
One more person, Your Honor.
Oh, I could see you on the other.
Yes, Your Honor, but if I unmute, I think I'll mess up our sound.
Okay.
So I'll just come over here and just Bree West as co-counsel with Craig Capua and Dan White.
Great. Let's get started. We have a number of motions here today. We have a first and second motion for new trial. We have, that was, I think, filed by Holly Martin. We have a motion to modify, and I believe we have a motion for contempt as well. Are those all the hearings we have set for today?
Your Honor, I have four motions that are before the court. The two motions for new trial, a motion to modify, and a motion to quash the subpoena.
Okay, I didn't see the motion to quash, but okay. What do you want to start with?
I'd like to start with the first motion for new trial.
Okay.
This motion for default judgment was made relying on the service that was in the that was filed on the 15th of October, service made the 14th of October on my client. The service says at this time there was a, Your Honor's motion for substituted service. The server went to the house, and all he did was proceed carefully to place the above service folder, which was this packet of pretty much everything that happened in the case, and the other listed court documents on the concrete pavement at the house that my client had abandoned, leaning against the brick wall inside the enclosed portico, shielding the front door, where these items would be protected from inclement weather. And he also noted that the house appeared to be uninhabited. Well, it was, and my client has filed an affidavit. She left that house back in August, no intent to come back. Nobody was there picking up anything, forwarding mail, or anything else. She had never seen the summons or the complaint. That's in her affidavit. So although this was service permitted under the order for substituted service, it didn't get to her. And frankly, I think at that time, Mr. White has gone on quite a long time about how she fled the country back in August. Even to put that in to a method of substitute service seems to me disingenuous. So that's basically my argument, that the only, something has to be on file for 10 days between the return of service, 10 days between the filing and the actual grant of the default judgment. Here, that's exceeded far. But that's the only document of service. It's the only document they rely on. And it turns out to be no service at all. And I think the motion should be quickly granted.
Okay, response?
Thank you, Your Honor. First, Your Honor, I would like to direct the court's attention, and I'm going to use a share screen, Your Honor, so you don't have to worry about looking for any documents.
Okay, let me enable that. Go ahead.
All right, my first document coming up is going to be the declaration of Holly Bone. First motion for new trial. It'll come up in just one moment.
Is it working or no?
It's,
I'm having an operator error. I'm so sorry.
if you give me a
Well,
couple,
There we go.
Whoa.
Have you
what's
got it?
happening?
Because I've got it here.
I've got it.
Is this it?
Yes. Share
Well,
screen.
that's-
You wanted the Holly phone.
No, but you want Holly Bone?
yes, Your Honor, it's on the screen now. You
Okay.
see it?
What was the date of service again?
The date of service of the petition and citation was October 14th, 2020. But I want to first start with the declaration of Holly Bone, which defendant is relying upon for her first motion for new trial. If you go to page number 2, Your Honor, you'll see that it's not an affidavit as stated by Mr. DuBose. It's a declaration, number 1. And if you look on page number 2, it's now notarized. So then the question begs, is this declaration in compliance with Texas Rules of Civil Procedure and case law? And I submit to the court, it is not. I would refer the court to section 132.001 of the Texas Civil Practice and Remedies Code. This particular section of the Texas Civil Practice and Remedies Code states the requirements for an unsworn declaration. Subpart D states that the unsworn declaration made under this section must include a jurat in substantially the following form. Plaintiffs object to the declaration because it does not list the declarant's date of birth. It does not list the declarant's address. It does not list the place where this declaration was signed. And then I would refer the court to a Texas Supreme Court case styled Hayes St. Bridge Restoration Group versus City of
What
San
section of the Civil Practice and Remedies Code did you say?
132.001.
132. Okay, sorry.
And then
Go
I would
ahead.
also refer the court to the case styled Hayes St. Bridge Restoration Group versus City of San Antonio. The site is 570 Southwest 3rd, 697. And the jump page is 570. And if you look in note number 15, the Supreme Court acknowledged that in this unsworn declaration, it did not include the declarant's date of birth, and the court held that this unverified conclusory statement cannot be taken at face value. So with that said, Your Honor, at this time, plaintiffs request that the declaration of Holly Bone be stricken and not considered by the court.
Response.
Your Honor, and I've got it in one of my other documents too. I think it's the second motion. And in that motion, I state, Ms. Bone has signed a declaration under penalty of perjury because of the lockdowns in England, the time differences between Dallas and London, and the relative scarcity of notaries public in England when compared to the US. She was unable to get a British notary. Moreover, an international
So
notarization.
Mr. DuBose, let me just say this. I think the main concern I have, under Texas law now, you can use a declaration generally instead of an affidavit in most, if not all situations. So I don't have a problem with the fact that it is a declaration. I do have a problem with the fact that it didn't follow the form of 132.001, particularly in this case where the allegation is that your client and her husband are trying to kind of hide out and avoid participating in this case. The fact they didn't include her date of birth, it didn't include her address, I think in this case in particular, but it's also required by the law, I think makes this probably fatally defective.
Well, Your Honor, then I've reset this hearing for a couple of weeks out, and I will provide all that material on her declaration.
Okay.
So let's just set this hearing off. Can you set, there's a time limit on the motions for new trial. I don't think we're running up against it yet.
I don't think
like
in this case, because this isn't a complete motion for new trial, this is just interlocutory anyway, so you don't even have that issue. So we don't have a final judgment here.
Okay. Well, I will get that. Now, this objection was not raised in their response to this motion. And I probably, had they done that, I could have had it done here today. They filed a response on Friday, did not mention this at all. I'm in contact with my client. I could have had that before the court. So let me ask the plaintiffs, are there any other objections you have to the form of the motion?
Well, at this time, that's the only objection.
Okay, are there going to be others? And can I ask, if you have other formal objections, that you get them to me at least 3 days before the hearing? Can you do that?
I guess my response, Mr. DuBose, is I will follow the rules of evidence and procedure in Texas.
Well, okay, be that as it may. So we will put those off.
I will say this, that it would be helpful to know these in advance. So that, as much as I enjoy seeing all of you guys, this does take up quite a bit of time. This case has taken up a lot of time. And so the extent we could streamline this and get to the merits, I think would be useful.
I agree, Your Honor. Unfortunately, it came up at the last minute. I do apologize for that.
Okay. What's your next motion, Mr. DuBose?
Next motion is the motion to quash. And the real substance of my motion is in the reply that I filed yesterday evening.
I haven't seen that. So what tell me what the issue is.
Well, the issue is, in California, they have rigid procedures for the filing of a subpoena for business records in California, where the suit for which the documents are sought is not a California proceeding. They have, the plaintiffs have sort of used that form, but there are.
Is this a motion to quash the subpoena to Google?
Yes.
Okay.
And let me see if I can bring up, and under those rules, now, the plaintiffs have given us two versions of the subpoena. Back in February, I think it was on the 21st, they sent out 4 different pieces of the subpoena. When you put them all together, they don't make a whole subpoena. But that I have attached to this motion as Exhibit A. And then in their response they filed another document, but they are both inadequate. The first thing is, in the form, they have to list all the attorneys of all the parties in the out-of-state suit. They didn't do that. So it is not, in fact, a subpoena, an enforceable subpoena, because it's a very rigid, just like California does a lot of this stuff, very rigid rules that I've cited and quoted in my response. The next thing that they didn't do is one of the things that you have to do in this form is whoever served it has to say what person they served, when they served, and what kind of, are they a licensed California service agent? That portion is not filled out at all. It comes with, in their response, a cover letter to Google. But in California, when you serve a corporation, you have to give the name of the person they served. And if they have, and this I found out in the federal suit I filed, when I served the agent for service process at Google, the person who received that document at the agent's name was in it. So I don't think that this has been served on them. The other thing is,
Let me ask this, Mr. Hurst, are you joining this objection or not?
I'm not, Your Honor. I could give you our position if you'd like, but
I would. I mean, this is a subpoena to y'all. So if you have a procedural, if you have a objection to the form of the subpoena, then I would love to hear it.
we have filed no objection to the form of the subpoena. I just want to note, if I could, Your Honor, for the record, plaintiff already sent and Google already complied with multiple subpoenas prior to this recent subpoena. And we've already complied with the previous subpoenas such that plaintiff and their team have quite a bit of information already about the four main channels at issue. It's not like these most recent documents that have been subpoenaed are going to suddenly provide all the answers about who owns the channels. Here's the issue.
I'm sorry, Mr. Hurst, could you repeat the last thing you said? I think I misheard it.
Sure. It's not like these most recent documents that are being requested are going to suddenly provide all the answers about who owns the channels. And I'll tell you why. I know I've mentioned this to Judge Jordan at the mediation, and I think I've mentioned this maybe in open court to everybody else, but a user doesn't have to use his or her real name. They don't have to use his or her real email address or anything. Brian Martin or Holly Bone can sign up as Mickey Mouse with the email address mickeymouse@gmail.com and an address of the North Pole, and they can still get an account. And that's not unique to Google. Many other online services do not verify driver's licenses, passports, etc. So I'm trying to be as much help as I possibly can to the court and to the parties involved. And that is essentially, you got to follow the money. Brian Martin did have one channel AdSense bank account combination that last received revenue in April of 2019, and the records we already produced show that. So we've been telling, I guess, Judge Wyde since October 2020. What you really need to do is you need to ask the MCN, the multi-channel network, what accounts it wires revenues to for the four relevant YouTube channels, both historically and more currently. And that is going to help answer at least part of the question. It's still possible Mr. Martin switched all those bank accounts all over to Holly Bone's bank accounts years ago, and that wouldn't probably surprise me or anybody else. But the best thing that can happen for the plaintiff in this case is that he take the deposition, follow the money, try to figure out where from the multi-channel networks where the wire revenues are going. And that will be the best indicator as to where that money is and who owns it.
Your Honor,
Mr. Hurst, if I understand how this works, and correct me if I'm wrong, because I'm only hearing little bits and pieces of this, is that, so if somebody has a YouTube channel, what you're saying is that they register that, but they just register that in an email address, not in a person's name necessarily. Is that right?
Well, they could put up their name, but it's not. They don't have to put their real name on there. They could put
Okay,
an alias on there, and they often do.
So in this case, if you know, I don't know what's going on.
So I hear somebody else talking there.
Yeah, I apologize. I'm not sure what's going on there.
Okay. Oh, sorry.
So in this particular case, who were these websites or these YouTube channels registered to?
Are you talking about the four that have already been done, or
The four YouTube channels?
I don't have that's the specifics in front of us. We've turned over all of that information previously.
Your Honor, I can tell you that Futuristic Hub and Creamwork Animations have Holly Bones' name on them.
And they have since the beginning?
Yes.
Okay, and then these AdSense, so you register at the beginning for the YouTube channel, and you can change that, I assume. Is that right, Mr. Hurst?
Yes.
And
they
that information's all been provided, is that correct?
That's correct.
And then when the revenue is sent out, it's sent out to one of these, what did you call it, multi-channel?
Yeah, MCNs, multi-channel networks.
To the multi-channel networks, and then and those are not affiliated with YouTube?
They're not part of Google or YouTube.
And then that entity will then transfer the money to whoever is supposed to get it.
Yeah, right. Who's ever directed to get it through the MCNs.
Well,
So
the MCN here, the guy
Mr. DeVos, Mr.
Okay.
DeVos, I'm talking to Mr. Hurst,
Yep.
and so let me do that, and I'll chat with you next. So, who sets up the MCNs? How does that get set up?
They're separate, independent company. I mean, I think it's a separate, independent deal. I'm not sure who manages these particular MCNs. The documentation, though, has been turned over to, again, the parties as to who the identity of the MCNs and who they should be finding out who the wire transfer.
YouTube and Google wouldn't necessarily know the names of the folks who are getting paid by the MCNs. Is that right?
That's correct.
Okay. And in this case, do you know if they knew or not?
My understanding is they did not know. My understanding is that's within the domain of the MCNs.
Okay.
and
All right, Mr. DeVos, go ahead.
the MCN, we already have an affidavit from the fellow who ran that MCN, which was called Freedom Family LLC, which Google has terminated because of actions in this case. He was trying to get Holly's copyrighted material to her. Google said, "You have, you're putting us in danger of being held in contempt," which I think is unlikely, and they cut him off completely. It's a business he valued about $120 million. It no longer exists. All it has to do is get the properties out. I don't know what I know that their records are going to show, because his affidavit says that is already on file in this case. George Venos, and is attached to a couple of these things, that it was going to Holly.
Your Honor, may I respond?
Sure.
I believe we have evidence to establish that Holly Martin did not create and did not own these channels since 2012, as she states in her unsworn declaration. I believe the evidence is going to show that, in fact, Chrissy Martin, who is Brian Martin's first wife, and Brian Martin were involved in the business and ownership of these stations, and that Holly Martin's ownership did not occur until after the trial in 2016, and until after Brian Martin got divorced from Chrissy Martin in March of 2019. Then he married Holly Martin 3 months later in June of 2019. So there's a lot of facts here, Judge, I think that we already know. I think more to be developed, number one. And number two, as it relates to the Google piece, I thought Google was under the obligation to issue 1099s to all of these various channel owners. And we've requested the 1099s. I haven't seen any yet, but I think that would probably shed some light on who the owners are, because I would suspect the 1099 would be issued to the channel owner. And, you know, if Holly Martin has been owning these channels since 2012, like she says, then I should be able to see some 1099s. I suspect the government.
Is that right, Mr. Hurst?
I don't think that is correct. And I don't know if the 1099s would go to the MCN or not, but I certainly confirm that. Look, whatever documents, would be, assuming if Your Honor denies the motion to quash and we finally enter into the.
I'm going to go ahead and deny the motion to quash. Anyway,
Okay.
Is there anything else we need to talk about with the motion to quash?
The only thing is just we need to get the protective order. I've got, I think I told you we sent a protective order to to the plaintiff's counsel about a month ago, about a week ago or so. They sent they said that was too long. I'm going to send you a shorter protective order. We owe them back some revisions. I should be able to get those to them today. Assuming the protective order is fine, then we'll produce the documents pursuant to the subpoena subject to the protective order.
Okay, that sounds good. All right, and you said there was a fourth motion, a motion to modify, is that correct?
Yeah, it's the order that makes all discovery secret in this case. And I think that my client should be getting copies of these, of the discovery that's out there. There really aren't any secrets as to who the parties are. And there is, my client is the target because it's her money that's coming out. And we know where her money is coming from. So the protective order that was entered back, I think, in October, which keeps everything secret. I
thought the purpose of that was basically you had a lot of confidential financial information about Mr. Martin primarily, but also to, potentially Miss Martin and others. So I think that's kind of where that came from. I didn't realize that we were trying to keep Miss Martin from being able to be involved in the discovery process. That wasn't my understanding. So if there's some language in there that indicates that probably does need to be changed.
Okay, that's all I've got. I'm going to send out. I haven't had a chance to send out discovery, but I am going to ask for all the discovery that has been received from Google and YouTube.
Mr. Capua, I'd urge you to negotiate with Mr. DeBose over what language needs to be changed in this order, if any, that will allow him. Ms. Martin has the right to participate in discovery just like any other party does. And I do agree that we need to shield the general public from some of the financial information that's going to be, that has been and will continue to be shared in this case, but that doesn't mean that the parties can't get it. If there's something in particular if there's some particular concern about, hey, we're worried that I can't even fathom what that would be, but there's some protection that Miss Martin could do to your clients by having open discovery. I obviously will consider that, but that wasn't my understanding what the concern was.
Of course, Your Honor, if Mr. DeBose would send me a proposed protective order that he wants submitted in the case, I'll certainly be happy to look at it.
I'll do that.
Anything, and then we had also a motion for contempt set for today. Is that correct?
I believe so, Your Honor. Ms. West is going to argue that one.
Okay.
Your Honor, may I be excused? I think that just doesn't involve my client.
Who's
Well, it's your client's husband, right?
Yeah.
Go ahead, Ms. West.
Thank you, Your Honor. We needed to play a little musical chairs for a moment. Initially, Your Honor, because this is a motion for contempt, can I ask the court to request that the bailiff either check the courtroom as well as call the hall to see
Yes,
whether or not
please.
Mr. Brian Martin is
Nancy,
present?
can you go and call the halls for Brian Martin? The bailiff is now calling the halls for Brian Martin.
Thank you.
And I
Your Honor.
want to note that my recollection is that the show cause order indicated that Mr. Martin was to appear here in person. Everyone else is going to be remote. Is that correct?
That's my understanding, Your Honor.
Is there anyone even out there? She's not. Is there anyone here, potentially Mr. DeBose, that would be here on behalf of Mr. Martin?
I don't know. He's not my client. I don't deal with him.
The bailiff has called the halls 3 times and there is no response to Brian Martin.
Thank you, Your Honor. I would just ask whether the court would make a notation on the electronic docket sheet that Mr. Martin was in fact ordered to appear in person by the court and has in fact failed to do so per the calling of the hall
Let me
by the
do that
bailiff.
right now.
I'm a little curious how an order can affect him in another country without going through the extradition provisions.
You mean in terms of like enforcing it?
Well, if we issue an order in the United States for somebody in the United Kingdom to be here, that has to go through the extradition
Mr. DeBose,
treaty.
he's a party in this case. He's not
Doesn't
a-
matter. I don't think.
Well,
Typically the person who is being moved is a criminal defendant and who is a party in a criminal case in the United States. So
I agree with you. The enforcement on this may be tough, but I don't agree with you that there's been some kind of defect. He's a party in this case. He's received notice of this, and he's chosen not to appear. If he comes back to the United States, then he'll be subject to arrest.
Yeah, that's certainly what our research reflects, Your Honor. And we would there's an additional component to the potential enforcement of it, which would be should the court determine his violation is sufficient and therefore is issuing a capias, that we would ask that the court draft a letter to send to the State Department so that when and if he returns to this country, there will be a flag on his passport.
That's a good idea.
And as you're entering that notation, Your Honor, there may have been some conversation at a previous hearing where Mr. Martin was ordered to appear at 1:30 and then possibly at 3 o'clock as well. Do you recall that? Because I'm sorry, Your Honor, because I think that there was a bit of confusion. This was originally set at 3 o'clock. This hearing was originally set at 3 o'clock. It was then moved to the 1:30 docket. And so in the event that additional notice wasn't given for the 1:30 docket and he only received notice for the 3 o'clock docket, we would ask, I guess, that the hall be called again at 3 o'clock just to ensure, he was given an opportunity to appear.
I don't recall any of that, but you may be right. I don't recall us moving the time, or at least I don't really personally being involved in that discussion.
Okay.
I know that we've had this set a couple of times and I canceled one of them at the last minute because we had a trial and then there was some issues with that. And so we just, in abundance of caution, we did that. Nancy, make sure to call the halls at 3 o'clock as well, and for Brian Martin.
Thank you, Your Honor. And so at this point, would the court sort of like to hear our full basis for why the show cause should be granted?
Yes.
Thank you, Your Honor. I'll try to be as brief as I can, but there is quite a bit. First and foremost, our motion for contempt and the court's order to show cause was essentially to address Brian Martin's failure to appropriately respond to post-judgment discovery, specifically requests for production and interrogatories. Plaintiffs served Mr. Martin with post-judgment interrogatories and requests for production back in November of 2020. Mr. Martin filed deficient and substantially misrepresented amended responses to the interrogatories and to the request for production. Now, having said all of that, Your Honor, I have copies of all of that. What is the best way to submit those to the court?
Copies of, I'm sorry, say that again. Copies of what exactly?
We have copies of the post-discovery request for production and interrogatories.
Did you want to admit those as exhibits?
Yes.
Okay. Go ahead and admit those as exhibits, and give me 1 second. Hey, just 1 second.
And I believe
he's offline.
So if I understand what you're saying, I would suggest admitting them as exhibits. Does that make sense?
that does make sense, Your Honor. And just for the court's ease, all of the things that I'm going to request be admitted at this point were all attached as exhibits to the motion to compel.
Okay, then to the original motion to compel, then I can take notice of the court's file if it's already in the file.
Yes, Your Honor.
Whichever you
And it
prefer.
is, well, we would request that you take judicial notice of the contents of the court's file, the entire court's file.
Okay.
And I guess you tell me, Judge, if it would be easy for you for me to admit them as well, or what is the best way to proceed forward?
I don't have any particular, if you feel like you need to admit them, because I don't have a preference either way, but if you feel you need to admit them, I'm okay with that. I don't have a preference.
Okay. Then I would ask that you take judicial notice first and foremost.
I will.
Thank you. And then just for the record, so it's clear, plaintiffs would offer Plaintiff's Exhibit A, which is post-judgment request for interrogatories to Brian Martin. Plaintiff's Exhibit B, which is post-judgment request for production of documents to Brian Martin. Plaintiff's Exhibit C, which are Brian Martin's amended responses to interrogatories post-judgment. Exhibit D, Brian Martin's amended responses to request for production. Exhibit E, Brian Martin's acknowledgement of a Swiss bank account that existed between him and his first wife, Chrissy Martin. Exhibit F, which is a telephone call between Brian Martin and original co-counsel attorneys, which the court there's a link that's included in the court's file where the court can listen to that actual recorded telephone call, Your Honor. Exhibit G, which is probably the most valuable to the court, is a summary of the acts of contempt by Brian Martin, action by action. And then we've just included a summary of definitions for the court to review as it relates to the request for production and interrogatories.
So these are exhibits you're offering right now?
Yes, Your Honor, and they're being scanned. And so what is the best way for?
Send those to Tony, who's my court reporter. Tony, can you put your email address in the chat real quick? And just don't say anything right now so she can do that. We won't be on the record. You see that, Ms. West? It's in the chat. You got it? Okay, good. Go ahead, Ms. West.
Your Honor, may I have just
And
one
those
moment?
exhibits are all admitted.
Thank you, Your Honor. May I have just one moment?
You may. Ms. Pettit, are you there?
I am, Your Honor.
Just because I'm trying to figure out some scheduling issues, are you guys going to still need the 2:30 hearing, or are you all
Yes, Your Honor.
canceling that? Okay. All right, Ms. West, we need to get this finished up.
Yes, Your Honor. I have one additional exhibit to offer, which would be Plaintiff's Exhibit I, which is the final divorce decree between Chrissy Martin and Brian Martin.
That is also admitted.
Thank you, Your Honor. And just to wrap this up, we would ask that the court take judicial notice of the notices that were issued for today for the show cause hearing for Brian Martin to be physically present, that those were issued and properly served on Brian Martin for his appearance today.
So noted.
And obviously that Brian Martin failed to comply with the court's order.
Okay. Anything else, Ms. West?
I think that that's everything as it relates to the motion for contempt and the show cause. And obviously we would ask that the court issue capiases for Mr. Brian Martin.
So is
For
Mr.
failure to
Capua
appear.
still there, or did he leave?
Nope, he's still here. We just had to move around.
So, Ms. West, Mr. Capua, you guys have been in my court extensively, and I've always, have an excellent reputation. I would ask for you guys to send us a proposed orders on all of this. I would also ask you to carefully look at these orders. There's been some issues in the past where things have been put into orders that I didn't feel like I actually ordered. And I didn't catch them because I thought they were boilerplate, which is my fault, but that's part of, you trusting attorneys. And so I would ask that you look at this carefully, the orders that you submit, and that they comply with the orders that I'm giving and not adding additional things that I haven't ruled on. Okay.
Yes, Your Honor.
Thank you, Your Honor. And very briefly, I'm sorry, there was the additional failure to turn over by Brian Martin his list of non-exempt property that was also at issue today, and if the court can make a ruling on that.
Court finds Mr. Martin is contempt on all of the grounds stated.
Thank you, Your Honor.
And the court will issue capias as requested.
Thank you, Your Honor.
And if necessary, if there's anything that I need to fill out for the State Department or anything, or any orders I need to sign or whatever for the State Department to effectuate this order, unless it's something that is way beyond the scope of what we've discussed here, I'll also sign those as well.
Thank you, Your Honor.
Anything else, Ms. West?
Not at this time, Your Honor. Thank you.
Anything else on this hearing?
Am I freezing?
You were frozen for a second.
Nothing else from the plaintiffs at this time, Your Honor.
Okay. Anything else, guys?
For me, Your Honor, it was great to see you.
Okay. All righty. Well, I'm going to go ahead and let you go. Ms. Pettit, Mr. Scott, I need to take a break, and I'll be back at 2:30, okay?
Right. Thank you, Your Honor.
Thank you.
Thank you, guys.
Thank you, Your Honor.
Hey, guys, sorry about that. Is everyone here?
I think so, Your Honor.
Mr. Scott, are you there? Oh, shoot, I was live on YouTube that whole time. Oh, well. Okay, so let's get started. Let's go on the record on cause number DC 2018633, Zatoun versus Alshami. Counsel, make your appearances.
Your Honor, for the plaintiffs, Jordan and Aaron Zatoun, is Jonathan Scott. Good afternoon. Your Honor, I would ask that this matter not be live streamed today. We do have some sensitive matters to discuss, including, among other things, that the defendants have publicly filed, the settlement agreement that has a confidentiality provision in it.
Okay, any objection to me going off of YouTube by Ms. Pettit?
I dispute the allegation, but no objection to going off YouTube.
I do want to note before I go off of YouTube, I am in the courthouse, and so if anybody is here watching this at the courthouse, they're welcome to come on in and